Hey, I've just finished marking all of your second assignments, and I just wanted to take a little bit of time to give you some overview feedback. Um, Overall, I was pretty happy with them. It's definitely a challenging assignment, and some of you stood up to the challenge, some of you had more difficulties. It's very practical, and some of my feedback really goes to thinking about what the assignment is. One of the things that I saw on too many occasions was that people weren't necessarily thinking about what is the purpose of this piece of communication. So were there really four deliverables if we think about the bibliography or reference list. Firstly, and not necessarily in the order of presentation, you've been asked to write a letter of advice and provide a markup of a term sheet to the client, and then to support that with a memo or some information to the person who needs to sign off on that letter so that they know that it covers all of the important things. And one of the issues that we had is people weren't thinking about, well, what's this for? Now, assessment, sometimes it's just checking, do you actually know the things that you need to know? But also it can be formative. So this is very much a learning task, and basically gave you an opportunity to solve a pretty complex legal problem, to explain the answer, drawing on the law and your research to another lawyer, and then translate that into something that made sense to a non-lawyer. But a number of you kind of got that a bit muddled up, and you really didn't think about, well, what is it that I am trying to communicate here? One of the things that I saw on too many occasions was lots and lots of information without sticking into what question are we trying to answer in this specific circumstance in relation to this specific problem. So that played out particularly in the marks, say, for the application of the law. Some of you are very good at identifying the relevant law, although in too many cases I saw law that really wasn't particularly relevant to these facts being identified, but then the application was less obvious. So let me give you an example, and it's also going to go to an issue that I didn't see addressed a number of times. So one of the key things that, for my money, is relevant to your client is the question of what is the status of this term sheet? Is it a binding arrangement or non-binding? If it's binding, is all of it binding, or should we have bits of it that are really just setting up the negotiation? So the relevant case law here is things like Masters and Cameron, Borkham Hill Private Hospital, etc. So a couple of you who did address this issue gave me quite a lot of information about those cases and the 3 or potentially 4 categories, but you never actually told me which category you wanted this to fit into and what you were going to do or what your recommendations were to make sure that it did in fact fit in there. And so again, it's one thing to tell me about the law, but finding the law is easy. Answering the question or knowing even what questions to ask is the hard bit. That's the bit that makes you a good lawyer. Sorry, I'm just going to quickly look at my notes here to make sure that I cover off everything. So another thing that I saw addressed in with different levels of skill was the question of what might be missing from this term sheet. And so probably one of the key things is it's not at all unusual for a purchaser to want to have an exclusive deal. That is an exclusive period of negotiation and for due diligence. Surprisingly small number of people actually addressed that. A couple addressed it really well and thought about what that meant for the term sheet. But again, it was addressed in a really way too few places. So I just wanted to bring that to your attention. Secondly, another issue, particularly from the client's point of view, is we've got a very broad set of instructions here. All we know is that they want to take a 1/3 interest. The term sheet was very much structured as a share sale and purchase, and there was this discussion of an earn-out. Now, there are lots of different ways that this could be structured. Very few people really brought that together in a meaningful way. So a few of you, and I think it was relevant to do this, discussed what would happen if it was a share subscription. But I didn't see as much strength in that as I was expecting, because clearly if it was structured as a subscription, then there was then the new money would go into the expanded capital of the company, and the deal could be dealt with in a different way. There was this idea of an earnout in the term sheet that was dealt with a very clumsy kind of deferred payment mechanism. And again, I didn't see very many people really delve into what that meant. This task was very much an opportunity for you to look at a draft agreement, to think about a deal and ask, what does this mean? What does it mean for our client? What's going to be in our client's best interest? What are the legal positions? Trying to understand the commerciality, but holding back from giving commercial advice. So it was challenging, it was difficult. Most people got across the line in the end, but I did see many opportunities for improvement. But good on you for tackling what was a really challenging task. And really, we're pretty much towards the end now. I'm yet to mark the next set of discussion board tasks. We're heading up for the main paper, which is the critical assessment task. If you have questions about that in the lead up, please do not hesitate to contact me. And I'm more than happy to come online and talk to you about that as we go forward. But well done overall, and enjoy the rest of your summer. Cheers.